in this new lecture of jurisprudence, where I will explain some other layers of the knowledge of jurisprudence of the law. Not the first layers. The first rings I have explained in the last lecture, no? When I talk about the natural conceptions. That is more or less the first idea that we have in our mind about the law. Today, instead of that, I will explain two things, both legal conceptions. The conceptions that we develop, construct, when we know about the existence of one norm, that is to say, the analysis of cases, real cases, with the applicable norm. When we find one norm, one positive norm, one rule of law in the legal system, so then will be one analysis of that specific norm. So, and the analysis consists in two things. First, the notion of, and history of hermeneutics, because hermeneutics is the science to read the text of the positive law and so many other texts, and also the analysis of the legal message, all kind of message. I will talk about so many hermeneutics. So this is very important because it's not just the lawyers that used to work on how to read the norms, the text of the positive law. There is also so many people in the history of humanity, of the humankind, that developed so many techniques, methodologies, rules to understand what we are studying. And then we will have an analysis of the cases without applicable norm. What happens if we don't have any rule of law, positive rule of law, any positive law? Well, obviously, we have to decide the case, to check what would be the answer, the legal answer in one specific case, and how we can do that. Well, we will see that it is possible using some tools, some instruments like Epikeia. I don't know if you have heard about Epikeia. Don't you? No one of you? Don't worry, because you will see this in this lecture, no? And then we can fill also all legal gaps with another thing, no? With the notion of equality, analogy, proportionality, among other things. But today we will see these two things. These are the learning objectives, as the slide says. No? For begin with this, I will put now, for begin with the notion and history of hermeneutics, I will put now this painting. I don't know if you know who is the author of this painting. Any one of you wants to try? Yes. Well, I will try to speak louder. In any case, who is the author? Tasnim, yes.
This person called J.M.W. Turner.
Very good, very good. Joseph Mylord William. And you know the history of this painting? It has a lot of history. Well, a specific story of Turner. It was, as you see, I will put now the title. The title is this, no? Is Snowstorm Steamboat Off a Harbor's Mouth, painted in 1842. No? And Turner is one of the most famous paintings of Turner, a very famous painter, probably the most famous in the UK. And he used to paint in this way, always seascapes, depictions of the beauty and breadth of nature, landscapes, stunning landscapes. No? But this painting is especially interesting. No? Why? Because he was in that storm. Turner claimed that in order to experience the torrent of the storm from a ship, he asked sailors to tie him to the mast so as not to be blown overboard. It's incredible. He said, I was there for 4 hours and I didn't think I was gonna survive. But if I did, I felt bound to record it. It's incredible, no? Because it's part of the life of Joseph Mylord William Turner. No? And as you see, well, is modern art. And there is, well, you can see, you can feel the storm, more or less. If you put all the attentions in the ship, you more or less see the ship. Probably you see some of the smoke of the ship. And you can also try to close your eyelids, no? Almost all like that, no? And you will realize that you can see better the painting of Turner. With that, you will realize, well, more or less, that you are in the storm and you cannot see very well the things as happen in the storm. When you are leaving the storm, you are into the ship, no? More or less, you take so many details with this technique. Well, it is quite good. Well, I enjoyed so much all the paintings of Turner, and that's why I think that it is the best one I have seen, the original in Switzerland. And I recommend so much this painting. No? It's not so big, but it's great. In any case, why I put this painting today? Because we need some technique to understand any message. Art is a message. It's a means of communication, of ideas. No? Any book is also a kind of art. For example, a novel, a tale, a book of history is also a message. And we need some technique to understand the author, to understand the message. And that's why this the question now, how to read a message, no? How to read a message. You can put a lot of technique in so many kind of message, no? And to answer this question, how to read a message, there was, for time ago, a science called hermeneutics, no? Hermeneutics, not just of the law, The first hermeneutics is not about the law. It's about another book that is most loved, more loved than the laws. The laws, the written law is not so loved, no? It's not so appreciated. This probably could be the book most loved in the world. Don't you know which could be this book? The most loved book in the world, in the history of the humankind. Yes, Rosalind.
Is that the Bible?
Yeah, you're right. Holy Bible, the Holy Bible, yes. Probably not just the Holy Bible, but all sacred books, the Quran, also the Vedas, also, so many are the most loved books, and that's why the people try with all his heart to understand this kind of readings as much as they can. No? And that's why in the very beginning of the history of these books, the people developed a technique to understand, to read as that books in a proper way. And for example, we have some notice about the biblical exegesis, no? The biblical exegesis in the 11th century before Christ. Imagine that, so far, in the 11th century before Christ, there in Israel appeared some guys called scribes. Scribes. What it means, scribe, copyist. Scribes, there were not only in Israel, also in Egypt and in Mesopotamia and in so many places. No, the people that used to copy some text, for example, the laws of the king, and so many. But in Israel, it was so incredible because the scribes developed a lot of technique to copy the Bible, no, the Torah at that time, no, the first books of the Bible at that time. I think that just 5 at that time, no? At the very beginning, no? They developed an incredible technique with a lot of rules, no, to copy that. No, for example, they could only use clean animal skins, no, both to write on and even to bind manuscripts. Each column of writing could have not less than 84, none more than 48, and no more than 60 lines. No, the ink must be black and of a special receipt. No, they must say each word aloud while they are writing to understand. To understand, they must wipe the pen and the wash their entire bodies before writing the most holy name of God, Yahweh. Every time they wrote. No? So there is a lot of rituals, no? And there must be a review within 30 days, and if as many as 3 pages required correction, the entire manuscript had to be done. But it is very, very interesting because, as you know, there is a lot of rules, and then not just for writing, for making a copy, but also for understanding the Bible, no? And with time, this technique for understanding, for reading the the Bible begins to be developed. So there, in the scribes and then so many schools in the Jewish people appears, no? And then in some of Christianity, no? The first rule to read, remember, hermeneutics is and biblical exegesis is a technique to read the properly some text. No? And the first rules that appear here is the literary interpretation. No? Let's the verse speak. We'll just hear what the text says, no? Says to us, but with which concept, which notion? Well, with the notion that we have in our minds, obviously, no? in our memory, in the usual way of communication. No? The problem is when one text have 1,000 years of existence. The problem is that probably the words change a little, the meaning and the pronunciation and the way of writing and so many things. And so there should be another kind of techniques to understand what is written. No? At the very beginning of the Christianity, probably there were 4 ways of reading the Bible, no? The literal interpretation, the moral interpretation, the allegorical reading, and the analogical reading. No? The literal is just to read as such the text. No? The moral, if you read, for example, Job, you will realize that there is a moral argument, no? Because Job suffered a lot, but he was always obeying God, and at the end his life changed. No? There is a moral answer of the suffering in Job. No? Well, it's not so easy to understand that Job, but in any case, this is the moral argument. And then the allegorical, no? When, for example, somebody talked about the David the king as a lion, no? As a lion, no? What is an allegory, no? What it means, a lion, no? Well, a strange, a powerful man that in front of God, in front of the community, no? Well, obviously it's an allegory, no? An allegory, using animals, using things to explain deeper ideas. And finally, the analogical. Augustine of Hipona used to use so much the analogical reading of the Bible, no? Making comparisons between some text of the Bible and some event of the life of his life or the life of the community and so on. No? So we will talk about analogy also in law. You will see. No? Probably you have some idea in your mind. Well, another rule to understand the Bible is to see what was the intention of the author, no? What was, for example, the intention of Daniel, when he wrote so many prophecies, no? Or Jesus, when he prophesied the destruction of the temple, no? Well, the intention is obviously to explain what will happen in the next years, no? But the people who read the Bible say, well, this is not just one short prophecy, because it's not just a prophecy of one event. Probably it's a prophecy of many events, no? And the people who read carefully the Bible realize that in the same words could be two prophecies, no? Two intentions of Jesus, and more or less in the prophets. No? First, to explain what will happen with the Israel in the next years, no? But also to explain what will happen at the end of the world, because the same things, but worse or better, will happen when at the end of the world, at the end of the days, no? So there is a double meaning, a double fulfillment of the prophecy sometimes. And it is very important, quite important to understand, to read the Bible is quite important to understand that not all the Bible is written in the same way, with the same genre. You can find in the Bible some poetry, no? Some poetry, no? The cantics of cantics. No, well, it's a song. It's a kind of song, no? With a lot of poetry, no? And so different is the narration of Adam and Eve, no? And so different is the explaining the gospel, no? The gospel. And between the Gospels, there are one of them written more with an historical technique, the historical technique of that time. For example, Luke copy, no? In this year, when Pilate was a governor or an authority in Israel, and he explained all the historical context, no? This is another technique, no? Another could be more or less like a tale, more or less, no? Explain, no? For example, Job, no? At the very beginning is the devil talking with God, no? Obviously, is explaining something that is real, but with a technique of what had to explain to the people, but in the reality seems to be that this dialogue, this conversation, I don't know, it could happen, no? In any case. Then you have to read each book, comparing the phrases, the paragraphs, and read comparing also all books between them, no? Because we believe, obviously, it is. I am explaining just biblical exegesis, not all kind of exegesis, no? Or of sacred books, no? Because we believe that the principal author of the whole Bible is just one person, God, no? That gives the ideas and put all the things that should be written in the mind of the authors, the people who write each book, no? But the main author is God, and the second is all the Luke, Daniel, and so many people, no? Who wrote each book of the Bible, no? And that's why we can compare between the books, no? In this book is said that, and in our book is said that, and we can compare, make some comparison about this, and it helps a lot to understand better the sense, no? Context could be the literary context, sentences, paragraph, books, Old Testament, New Testament, no? And also the historical context, no? For example, for understand better the prophecies of Isaiah or Jeremiah or so many people, it's so good to understand what was the political, the geography Israel at that time, the borders of Israel, no, and Nabucodonosor with his empire coming here, no. If you don't understand the political situation of that time, you don't understand the prophecies, no? So it's important to have some historical context. Well, there is a lot of rules. I just mentioned 5, no, here, but only to show you that the hermeneutics first appear with the most loaded text, no, and then we have another version of rules to understand the meaning of the message, no, and is the rules of this, no, of literature, of novels, tales, fictions, well, so many things in literature, no? So the people who analyze literature take care that there should be some technique to understand better the text, no? And it is called literary criticism. Literary criticism is an old science, very old. For sure, you will remember Aristotle, no? 4th century before Christ. He wrote poetics, no? Another little script also on poets, no? But the most famous it is poetics, no? And in poetics, it's incredible because Aristotle talked about so many things, no? And the rules of the theater, or of explaining things in fictions. Nowadays, the people who used to write, for example, scripts for Hollywood, for making any kind of film, use the same technique of Aristotle. It's incredible. It's incredible. I can explain so many things because I used the same technique to write a novel about pirates, and historical book about pirates of 4 centuries ago. It's incredible because you realize that Aristotle was a clever man in so many fields, also in poetry, you know. And there's a lot of rules, no? And a lot of classifications of methodologies to understand the text of the authors, no? One of that classification, it is the immanent and transcendent methods, no? The immanent method to draw conclusions from text. Directly from the text. You read the text and you can understand more or less, no? You can see in the text the style. How, for example, how the authors use the commas, the points, the end points, and so many things, or quote some other of or if he's speaking in first person or in third person. There is a lot of style there, no? Or the forms, yeah. Forms is also interesting, no? There are 2 forms, no? The accidental form and the substantial form. You will remember these 2 ideas of the last lectures, no? But and also in the field of literature, no? You can find two forms, no? And I have seen one case law about these 2 forms, no? About a rolling, no? Because there was a copy. As you know, we cannot copy another text, no? Because it is against copyright, no? And what is copying another text? Well, when you put the same words, the same phrases of the original book in your text, no? Without quoting, without mentioning that is not yours. Well, this is the accidental form, we can say, no? But also there is the form of the structures, no? The structure, because if you put one chapter first, and then another, as a consequence, another, and the structure is well analyzed by the literary criticism, because well, you have to put first to show the problem, well, to show who are the main people that is acting there, and then the problem, and then the last act, you will resolve all the problems, all the drama at the end of your novel. No? I remember one book that was the same, that had the same structure of Harry Potter, obviously without copying anything, but the same structure. And Rowling won that case law. Well, the judgment was against the ones who copy the structure, not the book. No? So, as you can see, to understand the one book, is good to know not just the phrases, but also the structure. No? And it is good also for any kind of study. No? I recommend strongly to my students first to when they study, first to see the structure of the book, the index, or of the code, just reading the titles. No? And then you will be able to understand why the author is telling me something in this part of the code, for example, or the book. So it is so important to understand better, to see the structure. No? You have a map of the book, and you will realize I'm here in the map. No? And that's why the author is telling me something. No? Okay, and we have also the transcendental methods. These methods study the text with external elements. No, is the contrary. No, what kind of external elements? Well, we will see that there is a lot of hermeneutics tools. No? Hermeneutic tools that will help you to understand, well, comparing with another text, for example, comparing with the history of the country, or the biography of the author. Well, there is a lot of things. No? It's now well developed, the psychocritic, no? How a text can have so many consequences in the ones who read the book. No? I remember one text now that is called Werther, of the sorrows of the young Werther. I think that is the complete title. No? Of Goethe, that was banned in whole Europe. Why was banned? No? Because so many people that used to read that suicide themselves. Because it was so terrible for all the people to read all that kind of sorrows. And the authorities say, well, we don't want the suicide of anyone, banned, prohibited. It's so famous for that now. This is a strong impact in the psychology of so many people at that time. Huh? And the psychotrics also analyze, well, the psychology of the author. No? There are so many analyses of, well, why the author, for example, paint that. No? There is two great guys, and for sure you have heard at least one of them, Van Gogh. No? He said in one question, why you paint the things as such? No? And he said, well, because I see the things in that way, no? The same happened with another Spanish from Greece author, no? Il Greco, the Greek, that used to paint a very larger image, no? Your same image, but larger, no? So someone asked him what happened, no? And someone said that he had some problems with the eyes, no? With the vision. And he used to see the things in that way, no? I don't know if the second one is true. In any case, I have heard that story. But the thing that I want to show you now is that people used to paint, used to write according to their psychology, to their vision of the world. And it is obvious, I think, that I'm not giving you any kind of new idea, but it helps so much to understand the books. If we know the author, the history of the author, and the psychology of the author, it will help so much to understand better and deeper the same text. And the poetics of imagination, well, many postmodernist authors use that kind of transcendental method, no? And their reception aesthetics. No? There is a lot of rules of aesthetics, no? How to show you one good thing, no? In any kind of science, no? Aesthetics. In poetry, as I told you, that kind of rules are from the very beginning, no? In the 4th century before Christ, Aristotle brought about many rules for make a good poetry, a good drama. Nowadays, it is still people using that kind of rules, no? But also in paintings, also the divine proportion, for example, no? or in music, no? In music, there's a lot of mathematical consideration, more than you can expect, no? And we can see just that rules to understand if the text is good or not. This is more or less the idea. So let's go again with this, and of course you will realize that there could be mixed methodologies that use immanent and transcendental methods, no? This is called the integrating methods, no? Use also environment data to see the meaning and so on. Well, it is not a lecture of literature, no? But it's interesting to know that from the very beginning of the history of the text, of the greatest text, no, there were so many sciences developed to understand as much as we can the text, the message. There's another science developed well, time ago, no? The third one. Read these kind of things. I don't know if someone of you can read this, no? Not so easy, because at that time there was no Google Translator. And it is the science that use the people that study history, no? Methods for read historical documents. Well, there are so many methods, so many rules in this field, in history. The science of history, always the first rule is also the literal reading of the document, or hieroglyphics or monuments or whatever you want, no? But the literal reading, first you have to take care what is saying, no? And try to understand what is the literal, what is the character or the word or the phrase. You have to have some notion of that word and to give some meaning, the literal reading. But then you have the history of the document and its source. The history of the document. For example, the code of Hammurabi, Hammurabi. Well, you realize that there should be one king that wants to put in just one stone, a big stone. I don't know if someone of you have seen that stone in the museum in the Louvre of Paris. Well, there is a big stone with the code of Hammurabi. And if you know the history and if you know well, the sources of that code, and if you know that there were so many witches and so many spellings, well, and so many things, magic and things, you will understand the code. If not, you will not understand neither the first line of the code that is about the magic and things and punishment. If you don't do very well the magic, well, there will be so many problems. No? It's interesting to understand one stone, the history and the sources, and the data analysis of the document. That could be, for example, the original document is more important than the copy. For example, the most important documents in history probably were copied so many times. One good example is the Bible. The Bible that is also a historical document, that it was copied so many times, 1,000, 100,000, 1,000 million times, in the history. But we have not the original. Obviously, if we have the original, what is most important if there is a contradiction between two copies? The original or the copy? The most important is the original, but we have not any kind of original, any kind of letter and so on. Paul signed it. We just have copies. So what happened with that? Well, obviously, the original document is more important than the copy. And the first copies used to be most important than the last one, because it's more close to the original document. And finally, there could be interpolations. I don't know if you know what could be an interpolation. No one of you? Well, okay. Don't worry, because that's why I'm here. An interpolation is an addition. It's so easy. It's an addition to the text, And for example, if you have two copies of the text, and one is more longer, quite longer, and the other is short, have some less things than the second one, which one you will prefer in two copies? The longer one or the smallest one? That is the question. Well, I don't know if someone of you want to answer. Which do you think that is more close to the original? Is the
longer one.
No.
Okay.
So, Duta, you have the second option.
Yeah, I was just thinking it's the shorter one because it has less additions, so it has less.
Yeah. I have explained you something about the Justinian Code. For sure you remember the Code of Ulpian, and so many. Well, it was discovered again 4th century before Justinian, and well, and there were so many people called glossators. No? For sure you remember that put a note, an addition to explain the things that they didn't understand. So usually the former copies have the first copies have less information, and the older one more information. Yeah, because the ones who copied that code used to put an explanation of the things that they didn't understand. That's why. No? That's why, and that is called the interpolation. No? That is a technique of the historical science. No? I'm talking here about the historical science. No? And if you discover an interpolation, for sure you will discover which year it appears. No? Because you see in the older copies there were not such phrase. No? It happened also in some parts, little parts of the Bible. No? And also in the Justinian Code, and also in so many laws. It is incredible. If you do an historical analysis of so many laws, you will discover these kind of things. Huh? And in the historical science, to understand the historical document, use also quantitative semantic research. No? That is the comparison of many copies. It's so easy, no? And the analysis of the content, and the analysis of the content has so many rules, so many rules. No, one that could be hard is difficile potio. What means difficile potio? No, difficile, the hard. No, the more challenging interpretation. Yeah, potio can. No. Is preferable, the more hard, challenging interpretation. No? For example, if you have some interpretation of one article of the Codex Civilis, yeah, but that is so simple and don't explain very well things. And you have a longer one, but that explains so many things, probably the second one is preferable. You have to choose the second one because it explains many things. Huh? This is a historical rule. We don't use this rule, or not so clear in the field of law. But in any case, I'm showing you on the literacy context also, as you see. And finally, the analysis of transcriptions. Literal, modernized, mixed. When one text is so old, imagine the Bible, no? Well, it's so hard to read, no? It's so hard. Probably now, neither the Jewish can read the original version of the Bible, because it was written in an old, in a very antique language, many languages, not just one, some parts. No? So the people used to translate to the modern language, no? And that's why you can find so many historical documents, also the Bible, translated with the original English, or with the English of Kenya, and you will read your Bible in a different way than in the United States is written, and in the UK it's different. No? One of the things that the independence wars of the United States have, one of the effects was the creation of a new Bible, the American Bible. No? It's incredible. No? And that's why there could be so many copies, one with modernized words, style, and are mixed. And the best one for the historicals could be the literal, no? Or the original. No? Well, as you see, I want to show you a few rules of each science, of each hermeneutic, no? To go to the four science, the science of the legal hermeneutic, no? Legal hermeneutic. How we can read the laws of Kenya? Well, for sure you have some idea, and you have some rules in your mind, and you will remember, well, this the literal rule, the literal interpretation of the laws. So I want to show you just a few, in a few minutes, a brief history of the interpretation rules in the field of the law. So I will explain now just a few schools of the law that explain how to read the written law. Remember, we are in this part, we have some law that should apply to one case, and we need to read as better as we can, no? And that's why at the very beginning, for example, with the approval of the Napoleonic Code, there were so many rules. First, in the academy, the scholarship of that time, and then inside of the code, of the first civil code, no, of the world, no, well, the first big one. The French school, the French civil school, said that the first rule of interpretations should be the literal interpretation. You just have to read the code and apply it. If you have some case, well, the case is the major premise, the code is the second premise, and the conclusion is the word of the judge. Yeah, more or less, not more or less a mechanical application of the law, of the code. So, but they realized that there could be some problem reading the book, reading that text, because from time to time it's not so clear that it applies, or the words of the legislator are not so clear. What you will do in that case? Well, the French jurist said that you have to see what was the will of the legislator, no? What was the will of Napoleon? And then you will realize, well, that probably he wanted to do a specific thing, and that's why you have to read this article thinking that you have to realize one aim. Well, that which aim, the will of the legislator. No? It helps, obviously. No? But if you cannot discover the will of the legislator, you have another possibility, no? To think about the general principles of the law, the principle of bona fide, of good faith, no? Or the rule that you don't have to harm anyone, or so many principles, the general principles of the law. And in any case, if this is still obscure, the answer for your case, you can apply analogy, comparing some other articles of the same code to apply to that case that seems that fits no well with any article. And finally, if not, you can apply equity. Equity. What means equity in the civil code is quite different from the the Anglo-Saxon equity. In any case, that are some of the rules. Those are some of the rules that the French school used to apply. Then, for sure, you will remember Frédéric von Savigny, the ones who was the founder of the historical school of the law. In the historical school, they appreciate so much the Volksgeist, the spirit of the people, and they say, well, it's good to know the spirit of the people and the history of the community to understand better the law. We can understand better the history. For example, I will put one evident example of my country. In my country, there was a huge crisis in the year 2000, an economical crisis with a lot of inflation and a lot of problems, and that's why the authorities decide to move to the dollar, to the US dollar. And at what point the Constitution said, no, the only official currency of the country is the sucre, at that time sucre. But the legislature approved one law to approve the dollar, and the law said, well, the dollar is also admitted in the country. It's also. Why they say also? Because the Constitution say that the only official currency is the sucre. But in the next day, nobody used sucres. Why? Because with the inflation, they will lost all the money that they have, and all people accept dollars. And you understand, if you understand the law, if you understand the history of the crisis, no? And that's why the literal explanation of that law is, well, probably we have also sucres, that because it was not banned. It was impossible to ban that at that time because in the Constitution say the contrary, no? But all people realize that no longer the sucre will exist. So it helps so much. It helps so much to understand any kind of law. You can apply the same thing for your problems in your country. There's another school you can find. There are so many Italian guys, Santi Romano, so many others. But also with a lot of consequence and with a lot of followers around the world, no? In any country of the world, no? The beginning of the last century, they used to, in the middle also, no? Used to study the whole legal system in a systematic way, no? And they realized that it's not so important to read just one code, comparing one article with another. The French school had also the context rule, but only comparing the one article of the code with another article of the same code, no? Well, the systematic school say, well, we can see that we can that there is so many laws in a country, and we can compare all of them, no? The context of phrase, internouns, and the structure of the noun, no? Also it's good, no? The systematic approach, see especially the structure of the noun, no? The titles, chapters, and so on, no? And the aims of the noun. This is very interesting, no? Because it's not here is not the aim, it's not the end, it's not the goal of the legislator. it is quite different. It is more objective, the aim of the norm. And it's easy, for example, to know the aim of the legislator when the legislator is just one person, Napoleon, or the president with our regulations, on a specific regulation. It's with just one person. No? What was the will of the, I don't know, the president in this resolution? Well, you can attend to some interview on the television and you will realize more or less he wants to something. But what about an statute law approved by your parliament? No? Where you can find the will of the legislator? Well, you will say, no, there is a lot of debates and a lot of the speeches of each legislator. And I will say, there is not necessarily the will of the legislator, because it's just one legislator, no? And probably all the other people, the other legislators, could contradict that guy and say absolutely the contrary things, no? And you can see so many speeches in a debate with so many positions. So what could be the will of the legislator? Nobody knows. Nobody knows. That's why PUCTA and so many others of this kind, these schools, anti-Romanos, it's better to see what is written in the same norm, in the prologue, in the preamble, in the first pages or the first lines of each law. That is a little explanation that why we approve that. Because that explanation is accepted by all the legislator, and that is the aim of the norm. That is a little different. You have here the will of the legislator, and this is the objective will of the norm. No? It's more systematic. No? There is another, not the school, but movement that have a lot of new rules to read the same laws. No? This is the constitutional movement. No? For example, the constitutionalist authors used to say, well, you don't have to see the aim of the norm. It's better to see the aims of the Constitution because the Constitution is a higher norm. Yeah. And if there is some norm, some statute law, some regulation, some policy, you have to read not just that, but in accordance with the Constitution. So you have to see not the specific aim of the norm, but the main aims of the legal system. This is another aim, no? Okay, Joy, you raised your hand. You want to say something?
Yeah, I have a question.
Yes.
With regards to the aim of the norm and how you can't, okay, what you said about when the parliament is constituted by many people, you can't know the will of the legislator. But I wanted to ask, in a country like Kenya, where a majority of the legislators come from one political party, and they have like, and the political party normally has an agenda they try to drive with the laws that they pass. So can you separate the aim of the norm with the aim of the legislator in such a situation?
Yeah. No, it's a good argument. Yeah. And probably you will realize that in that case, if the absolute majority have the same idea, the speeches of this party will help so much to understand the norm. Yes, I agree. But in any case, it's more objective, the written things that is the approved things, no? Because, well, it's the approved, and that's why it's norm, and it's enforced. Well, there could be. But what happens if there is not the majority and it's 51 against 49%? Well, it's not so clear. It's not so clear. And we can add that in the majority you have so many people that things from time to time a little different. No? It's not so easy to find two people that thinks absolutely equal in the same point. It's not so easy. It's not so easy. So, but I agree with you. In that case, it will help to understand better, but the history, and also more or less what could be the aim of the law. Yeah, I agree with you. Okay. But here is different, no? In the constitutional aims is the aims of the legal system. Well, and there is a discussion also between that is only the Britain aims, the Britain goals or ends of the Constitution, or could be another one. No? Well, there is a lot of discussions there in the jurisprudence of the United States and many countries. They accept that there could be another kind of aims, no? And in the same countries, there are some jurisprudence that don't accept that. It's incredible. I accept because I think that the natural conception, the culture could include implicitly so many things in the Constitution. Well, but it is constitutional. In any case, you can think about this, anything that you want. There is another rule of interpretation, the harmonic interpretation. No? The harmonic interpretation. What happens if you have a rule or a regulation, for example, no? that is against the Constitution, no? And you have to read that. Well, you have two options. You have normally, at least in so many cases, you have two options. No? At least two options. No? One, to say it is against is contrary to the Constitution, so we should declare this regulation null and void. It should fall because it's against a higher norm, and you know what happened with these kind of things. No? But another possibility is to give some constitutional understanding, not to read so literally that norm, but put him with some interpretation in accordance with the Constitution of any country. No? And in any country, the constitutional courts used to use that harmonic interpretation. And also the international courts of human rights used to use the harmonic interpretations of the rules of each country. And they used to say, I will not declare, I will not say that this rule is null and void because you should give some specific interpretation to this norm. And this interpretation will be that. Is the harmonic interpretation of the law. This is a new rule. Interesting, very, very interesting, no? In the constitutional movement. And the principle of proportionality that for sure you have read the last lectures when we talk about the principles of the law. Huh? I said that this principle is so important nowadays. It's very, very funny because probably for many constitutionalist authorities, the most important constitutional principle, but it's not written in any constitution of the world, no? And it is the most important constitutional principle. Well, in any case, you are not in constitutional law subject. That I just explain a little thing here. No? And finally, the human rights movement appears with a lot of new rules to read the same laws of every country. No? For sure you remember some of them that I explained in some of the last lectures. The principle of pro homine, or pro natura, or pro operario, and how it works in the legal system. So, as we see, we have a lot of tools, of rules, of standards of interpretation of the same noun, no? In so many sciences, no? In so many sciences, no? We will see more or less like 50, 60 today. We have seen a lot. We have seen a lot. And it will help you a lot to read, to understand better the laws of your countries, the country of Kenya, and the international treaties, and any agreement also. It will help you. That's why this lecture is so important. You will use all the tools that I'm giving now today in every day of your life, if you obviously exercise your profession, no? As a solicitor or barrister or professor or lawyer. No? So it is very important how to read the rules, the laws of the agreements and the treaties and the constitution. No? So I think that we can have the break now, 10 minutes. We will resume the lecture after 10 minutes. We will talk about the analysis of the legal message, but in a systematical way. It's not just an introduction of the history of hermeneutics, but the rules to understand, to read the message in a systematical way. And for this, I will use the same technique that we have used in the past for so many things. The technique of the four causes, no? Four causes. For sure you will remember this slide, no? A table, any kind of things in this world have some causes. Traditional, there are four causes, no? The wood is the material cause, the design is the formal cause, dining is the final cause, and could be so many also, no? But I mean the principal ones, no? And the efficient cause of the table is carpentry. So we can ask now, what are the four causes of a message? Because the first thing here, trying to understand better, is that the message is the laws, the written law is a message. And if it is a message, we will study that message. And how can we read? And how we can get the meaning of that message, understanding the message. So, what do you think? Which one could be the four causes of a message? Any message, an email, for example, or a written letter. Or a note, just a note. Or a call.
Can you say
Can you repeat me, because I didn't hear anything. The material cause, for example.
I said greeting.
Yeah. I don't know if someone, probably you can write also in the chat. Probably could be easier because I didn't see. Yeah. The meaning by the study of formal cause, it is design. Well, Ali, yes. Final cause is communication. Yeah. Communication of some specific idea. Yeah, good. Ali, yes.
I'm not quite sure, but the first cause I'd talk about is the immediate cause.
Yeah.
Within,
But the four cause, let's try the four. The material, think about a letter from your father.
the material cause being the language.
It will be in that written with a pencil. The material cause will be the material, which is the material of a letter that you have in the post.
As Michael said, it was
Is the paper.
the paper.
Okay. And someone said the words. Yeah, the paper, good, better, good. And the words not. The words is a form. Is a form. In some sense, could be material, but principally is the paper and the pencil that you use to write, and the charcoal that of the pencil that will be, or ink could be of a pen. The ink and the paper is the material cause, and the form is also the words and the final cause, yeah, to communicate something, and the agent cause, the efficient cause. Which one could be? The agent, remember, could be a subject or an action. The subject, who brought the letter? The messenger, well, the father if of that person, and the for who? For his son, for example, no? Yeah. Well, it is a good exercise because we will use the same exercise for the law, no? And for so many things. So the material cause is the paper, the pencil. Good. You got it. The formal cause, it could be the content, the idea, the words also, no? But not just, remember, there could be so many formal causes. One thing could be the words, the form of the words, but also the deeper form, that is the content, the idea that is behind, is hidden, and just an intellect can appreciate what is the substantial form, not the accidental form. No? And also, we can find also the final cause, that is to inform, good, to communicate. You got it. You hit the mark. This is the form. In some way, it could be also to communicate the idea, no? Communicate the form. That's why it's information, no? To put in form, the form in another mind, no? And the agent cause, obviously the sender and the receiver. You did it well. So let's put another example now, a legal example. A contract of selling and buying something, for example, no? Of selling, I don't know, your computer to another one. Which will be the material cause and the final cause, and so on. So what do you think? No one of you wants to try? The paper of the contract, okay. some one of you, well, this is the material, the form, material paper once again, because if obviously if it is a written contract, no, because if it is a verbal contract, there is no the sound of the words will be the material cause, no. The form, the terms, good. Lavender, yes. The terms, Ali, also the agreements of the terms, good, good, good. And the final of this contract of selling something on a computer. You have to remember the 4 causes of the legal relationship. Well, final performance, the execution of the contract, more or less legal bonds, obligations. Yeah, there is a lot of things there. But we will say first the common good. Don't you remember that the final cause of every legal relationship also here is the common good? What things could include the common good? Probably all this set of obligations, of duties, and of rights, a set of things. No? And the principal aim is, as Effie said, selling the computer, no? Selling for at least for some part, and for the other part buying. No? That's why it's common good. No, it's not just selling but also buying. Yeah, it could have a lot of things. No, the same. Yeah. So the material cause is paper, ink. Again, if it is a written contract. Formal cause, the agreement. Yes, really. Final cause bind the parties in a legal business, but this is one aim. The last aim is sell and buying and specific things and create a set of duties, and so the common good. No, we can synthesize that with the word of common good. And finally, the agents. It's so easy, you know, the parties of the contract. No? So let's go and finally, after these exercises, the 4 causes of the laws of them is, I mean here, not the 4 causes of the legal system. I mean here the 4 causes of the written law, of the message of the law. That is different, because now we are trying to understand the message, and that's why the question is the 4 causes of the message. No? So, no one of you want to try with, at least with the material cause? This could be a little. When I talk about the material cause, remember, it's the support of the message. Where you can find the legals, the laws of Kenya? Where? In which material support? Where? To Naima and to Vera. Where you can find the constitution? That's why the same constitution is not the material cause. No. Where you can find the constitution? I prefer if you talk, because in that way all of you will realize, for the video also, when you will see again, there will be no chat. But in any case, in a book, yes, in a book could be. Naima, you're good. In a book, yeah, probably could be in some book. Which kind of books? Where the laws of Kenya are published? In the government printer, yes, this is one. And in which other kind of support you can find it? For example, you can, I think that when you are walking in the street, you continuously are seeing some laws of Kenya in some signs. No, stop, don't park here, or a traffic light, no, with red, yellow, and green. No, those are the laws of Kenya. Yeah. And it's quite different support. I don't know if you realize that it's quite different support. And also you can have the laws in your mind. It's another different support. Huh? Your intelligence, you have so many, not all of the rules of Kenya, but some of them in your mind. There could be so many kind of supports. It is very interesting because it will help you to understand how to read the laws, in what kind of support, in what kind of support they are written, or where you can find them. Paper, digital means, words, also now customs. The customs. Where are the customs? Well, the material cause of the customs, the repetition of actions, not the behavior of the people. That is the material cause. In our mind, also in our mind. When we remember some law, we have the law just in our mind. It's not written, it's not pronounced, that no, it's just an idea, something inside of us, in our mind. No? So the formal cause of the SLE. Then you want to try to with the formal cause.
So would you try to say that? No, I'm just seeking clarification. I'm asking, could you say now that the Constitution exists in a form of a metaphysical form in the mind, like people just have it in their mind and not necessarily in its tangible form?
This is the living Constitution. Yeah, or cultural conceptions of the Constitution, or cultural conceptions. For example, now there is an issue, as you know, in the government. We will apply the 2/3 parties or not, or this is a legal issue. No? What did the people used to think? No, from the president to the last of the Kenyans. No, well, it is a question that you have to solve. I don't have to say nothing there, but it's just to show you that the cultural conception of the people have a lot of influence, and probably could be supported. Where is the customs or the conception of the cultural conceptions? In our minds. It's not, most of them could be written in any place, but could be on our mind. Otieno, yes.
I was also seeking clarification on when we say the material cause for the laws of Kenya are paper, should we mention constitution or acts of parliament? Or we're just mentioning paper? Like, I'm a bit confused.
Well, when I mentioned the material causes, where is supported and the same law that could be, for example, the Constitution, you can find in the printer of the government. Yeah, you can find in some publishers that publish a book. It's not the printer of the government, it's just a copy, but it's the same law. It's the same form, but the same form as the words, but in another support. And you can have also in the website that is not printed. Yeah. And the same constitution or the same statute law or whatever you want, you can find also, if you remember, if you read, you will find in the sound, no, the same law. But if you just remember in your mind, I don't know if it helps you. The material could be so many materials, no, but
yeah, it helps.
Okay.
Thank you.
Okay. But well, not by, please. Well, the formal cause is so easy, no? Is the Constitution and any kind of law, as well as in the contract. You remember, is was the agreement. Well, here is any kind of law, any kind of law, any kind of law that could be in so many supports. No, the final cause, well, is the aims of the legal system. We are talking about all, and each norm, each statute, each resolution will have their own specific aims, obviously, no? But that aims should be a part of the aims of the legal system. It's not. And finally, the agent cause. The agent cause, that is a tricky question. What could be the agent cause of the laws of Kenya, of the message of the laws of Kenya? The people. Well, who is the one who approves the law? That is the person who gives the message, no? The legislator. Good, the legislator, but not just the legislator. That's the idea. But also the citizens, because remember, it's not just a message, it's a message that a community used to live, not because that's why we are talking about the living law or the living constitution. All kinds of authorities, not just the legislator, all kinds of authorities, but also the people, no? Well, legislative, obviously the parliament, and good. So it is just an introduction, this slide, because each one of them have a lot of limits in the code, a lot of limits. And I will show you at least very fast how it could work, no? What I'm trying to, for example, material cause could be a sign, no? A symbol of not enter here, no? A car park. You can do that, you cannot do that. But also could be, for example, a gift. A gift is a message, no? Well, someone a flower, no? It expresses so much, no? Oftenly, no? It's more than words, no? As the song says, of extreme, no? More than words. To show what you feel, no? Well, it is interesting because depending on the support, well, you can express in a more vividly way, in a more clearly way, something or not. Probably in some conversations between two people, face-to-face conversations, we can talk face-to-face, you will realize so many things. But if I write 2 lines, I will not express so clearly my message. Yeah, and it has a lot of consequences in hermeneutics. You will see why, because the analysis of each legal message depends of the support of the message. What kind of support you can find, and there is a limit that talks about how you have to take care of the support to understand the message, no? And I will read those limits, no? Because the titles you can find here. The support as such, the circumstances of the legal message that is part of the support, we can say, and the realistic and evolutive interpretation is a new way of interpretation. I think that we have talked about that. Let's go now to the code. Well, I don't know if the size of the letter a little bigger. But first, I talk here about the analysis of the cases. in each analysis, you have to find first to realize this is important. I will go after that. First, you have to understand the elements, the subjects, the environment, the goods, then the material elements of the legal relationship. Then you will be able to understand which kind of written law could apply. And if you find one written law, any positive in law, for example, a contract, a resolution, well, you have to read that and understand that. That's what we are doing now. And here you have the legal support of the message. You can read well. I don't know if the size of the letter is okay for you. Do you?
Yeah. Yes.
Okay, great. This is the first one, the material support, where the message is based. No? Message can be recorded on a permanent medium. For example, a stone, the Code of Hammurabi is written in a stone, no? Or a paper, or can be said orally, as you see, the things that we pronounce is not a permanent medium, or expressed through acts. For example, if I give someone a flower, it expresses so much things, no? Gratitude and so many things, no? And also, for example, if the king of a country say no, just with the finger, no? Well, it's expressing something with one act, no? Obviously, this could be a law, a resolution of the king, but for a very, very specific person, no? Not probably will be not the law of the country, no? In general, what is done is worth more than what is written or said. This is this phrase of the second paragraph. It is also in the Roman law. You will find here so many dictums, so many phrases of so many countries. This, for example, the BGB in Germany, also, and also in Japan is the same phrase, in so many continents. And so it is not just because it has some reason, no? In general, what it means, for example, if I'm giving you something and I brought a contract, these are selling and buying contract, no? of my computer, but I put in the you and I sign the contract, no? So, but at the end of the day, I'm asking you every month, I don't know, $20, no? 20, no? Every month. And at the end of the year, I recover my computer. It is a contract of sell and buying or not? What do you think? No one of you? 1, 2, 3. Please repeat. Yes, Effie, yes.
I was going to say that it can't be said to be a contract of buying and selling per se. Yeah, because it's a different arrangement.
What kind?
I'd say hire purchase.
Yeah, I'm renting my computer. Yeah.
Yeah.
Because I'm asking continuously a monthly payment. At the end of the year, I recovered my computer. So it's not a selling. It is not. You can read in the contract, no? It's a selling, no? But the acts, the way that you are acting and me, both, no? It's so different. So, so what we will say? What we will say? The same thing that all the traditional legal systems say, no? In general, what is done is worth more than what is written or said. So this is the meaning, no? As when accepting adhesion to pay a debt or a satisfaction in the face of an injury, no? These are two examples. For example, if I sue a demand because I think that you injured me, but you pay me something and I accept that money, obviously the trial is finished because I accepted this, I accepted it, it is all done, I forget it. I pardon the offense, I give pardon, and so on. So that's the meaning of that word, no? But in general, let's go ahead. And also silence in Otupos give counsel, you know, obviously. If I see something that for example, the man who wants to pay me for that injury put the money in my house, I don't do anything to stop him, or I am accepting. With that silence, I am accepting the compensation that he gives me. So, but it is principally for well, let's see. Well, yeah, we are okay. I'm checking the time, no? But obviously, we can consider that things. Well, just obviously in contractual law, in any kind of agreements, and in face-to-face commandments. For example, the king that commands something to one of his people, no? Well, this way, no? But with the laws of a country could be a little different. We will see why, no? When people do not stick to what is written, what is said is worth more than what is written. This is a development of the same idea, because the first one is just in general, but here the people do not stick what is written, what is said is worth more than what is written. This principle especially prevails in communication between those who are present and in those with fewer interlocutions. No? There is so many rules of interpretation of the agreement that you have to be careful first of the intention of the parties first, no? And then you can see another things, no? Probably the written letter is probably could be not so clear, but if the parties are so clear about what they want, you have to take care more of the intentions. But it's different in the country. It's different in the country because a law could be written for so many circumstances of so many peoples, of so different space-time circumstances. So that's why the rules of a country should be written in a different way, not using obviously the intention can help, but will not the best one. Okay, we will see now. However, the written message or recorded in some medium deserves a more detailed and regulated analysis than verbal message and message expressed through acts. And it is clear, no? If I can say, don't do that, no, it's so easy to understand that, no? But the analysis will be not so deep. But if we read the Constitution, we can write books long books about the Constitution because it deserves a deeper analysis. Yeah, and it's possible also, no? Because it could have so many meanings. Yeah, that's the material support. No? The circumstances of the legal message. The knowledge of the following helps to determine the legal message meaning. And you will realize the historical precedents. No? We know that there is some history of the message. Well, probably it will help a lot, no, to understand. The same example that of my country, I will repeat now. No? The example was the currency. Until the year 2000, there was the sucre. The national currency was the sucre. And the Constitution said that the only possible currency is the sucre. But we had a lot of inflation and a lot of economic crisis and problems, issues, and so on. And one day the parliament approved the dollar, no? And never said that no longer will the sucre will subsist, no? Because it will be unconstitutional, no? But all the suffering of the people, the history of that, no? And the next day, all the people passed to the dollar, no? Passed to the dollar, use dollars, and nobody accepts sucres, no? The national currency of Ecuador. And all agreed in that thing. Why? Because the history. If you don't know the history, you will think, no, probably in Ecuador there should be now two more kind of currencies, the sucre and the dollar. Because the Constitution says the only, but I know that there is some, but if you know the history, you will realize that there is only one option. No? Now, only in my country, the dollar can be used. So this helps, no? And second, how it was subscribed, issued, promulgated, or published, no? And you can see, for example, there is a lot of studies of the norms of one country that the same bill that was approved by the parliament is not the same law that was published by the printer of the government, no? Because at the end of the day, the president put a comma and also changed a little word. It happened in all the countries of the world. Yeah, it helps you, if you are good lawyers, to give the best understanding of the law to your clients, no? So you have to take care about that, no? How each norm was issued or promulgated or published in each country. However, it must not be immediately inferred that these circumstances are identical to the motive causes of the legal acts, no? Or business or norms. For example, no? If now here in Kenya and in any country of the world there is a crisis of, we know, of coronavirus, no? In so many ways, well, we can understand so many contracts, but not all contracts are signed because of coronavirus, no? So it helps, but it's not the only rule to understand each contract. Yeah, it helps, and in some cases more, in some cases less, and in some others it doesn't help. Yeah, it's just one rule among many of them. So, and the last limit, the realistic and evolutive interpretation. I think that I have said something about this. It's good to understand how the things are changing, to understand the norms. in the past, I used to put one example that works in many countries. In the past, the telecommunications were not so developed, and that's why so many laws in so many countries regulated for example, the telegraph, no? That you put with a button, ta 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 ta. I don't know if you have seen these kind of communications. For example, in the for say SOS, no, you can put three times the same ta ta ta. This is an S. A longer one, ta ta ta, 3 times is an O's, and you put again ta ta ta. Is SOS. So if you are lost in some place and you only have this kind of means to communicate, you have now the idea of how save yourself. Just putting ta ta ta. Well, obviously it's a very antique way of communication when the telecommunications were not developed, no? And there were so many rules for this kind of artifacts, no? Of machines of communication, no? And also, for example, in the Constitution of the United States, say, well, you have the freedom of this kind of means, no? That no longer exist nowadays, no? So we can understand that probably the same rule, if now is in force, is valid, actually you should read this rule in another sense, no? Not seeing what is written, because the telegraph is no longer exists nowadays, no? But seeing the intention of the legislator, and seeing that when the legislators say, or the ones who have the constitutional powers to approve that constitution says about something about the post and the paper post and the telegraph, he probably is trying to talk about one broader right, yeah, a freedom of communications could be, no? Any kind of communication, not just the written post in a paper, nor the telegraph with the ta 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 ta, with any kind, but with any kind of means of communication. So this is another way to give an understanding of things, no? But yeah, and there is a problem here. There is a problem, and I will put you the problem, and I will ask you how you can resolve it. No, it's okay. The evolutive interpretation of each norm. No? There's well, as you know, there is a movement to approve any kind of marriage, no? Between anything or anybody, no? And one of the arguments for that is that I will not discuss the morality of this kind of marriage. I will discuss now just the evolutive interpretation, no? And they say, well, when the people approves in their constitution, is a debate in, for example, in so many countries, but also in the United States, also in Ecuador, also in so many countries, no? And many judges used to use this argument, no? When the Constitution was approved in the past, saying that the marriage is between men and women, the society was so different, and now the people are thinking in another way, and that's why we should apply the evolutive interpretation. And that's why if the people accept other kind of marriage, we have to interpret the same norm in another, giving a new sense to the right to marriage, to get married. So with the same evolutive interpretation, they allow the homosexual or egalitarian marriage, as you wish. No? What do you think about this evolutive interpretation? Do you agree? Don't you? Not about the morality of this kind of marriage, but about this kind of interpretation of the norm. Do you agree with the court of the Supreme Court of the United States or not? Yes, Ali.
I totally agree with it in the sense that its evolutive form tends to appeal to the different beings, their potentialities, ends, values, and principles, to be emancipated than being oppressed in the liberated sense. So I'm not saying that the dilution of those laws in and of itself is necessarily something that ought to just be accepted, but I'm saying in its evolutive form and its expansive form of expanding freedom and the potentialities, ends, and values and principles of individuals is what seeks to maximize justice and equality within the society. So I agree with it and its evolutive form and elimination of regulations that existed to cease.
But the question, I will give you a clue to answer this. No? What should what kind of things can evolve? The evolution will be verified in which kind of things?
Values and norms in the society. Values and norms.
This is another way of interpretation. The evolution,
which kind?
The evolution should be verified in the facts, not in the beliefs of the people. Because if on the other hand, the problem with that kind of jurisprudence is that never just the judge said, no, all the people now things in this way. And if you go to the surveys, say the contrary, and they don't prove anything. It's just a phrase of the judge. No, all people now thinks in another way, but without any proof. But if you want the will of the majority, you have to approve another rule. No, it's interesting. It's so different in the case of the telecommunication, because in the telecommunication is an evolution of the facts. Now, just in the past, it's not a matter of the mind or the will of the people. It's not a matter of the evolutive interpretation is a matter of how things in the extramental reality have some kind of evolution. Yeah, first thing, and that's why you can see, well, the human nature is the same 2 centuries ago, and now 2 centuries ago, when the Constitution of the United States was approved, we will say yes, the human mind is the same. The humankind is the same, no? The same nature, because marriage is a thing related with the nature, not with the will. And if it is the same, we cannot apply the evolutive interpretation, because it's the same. Yeah. Another thing I will say, the same argument was used in several countries to approve abortion. And I know at least 2 countries, and also one international court that used that argument, no? That, well, you have to interpret it in an evolutive way. But if you see the constitution of that country was approved 10 years, less than 10 years ago. So in 10 years, the judge said, no, now the people used to think in another way. So, and with that phrase, you give license to whatever the judge wants, whatever. It's incredible. So I will say, I accept, at least it's my opinion. You can think about this, anything you want. But my opinion is that it's possible an evolutive interpretation of the norm, because remember, the ones who read the norm is not changing the meaning, it's just reading the norm. It's just reading the norm. Yeah. So I accept some interpretation, but if there is some change in their reality, because rebus sic stantibus, no? And you will remember that clause, no? That is implicit in every part. But if the things change, probably we can change, and as much as the reality, the physical, the extramental reality change. If it's not just a matter of majorities, no. It's, well, this is the realistic. Sorry. Let's go ahead with another part of this, no? That is the analysis of the purpose, of the aim. We have said something about this, no? There could be three aims, the final cause of the legal system. Don't you remember these three kinds of aims? It will help. Three kinds of aims. I mentioned those aims when I talked about the historical school, the French school, and the constitutional movement. No one of you remember the three different aims that could be possible to find in the legal system? No. One is the aim of the legislator. The second one is the aim of the norm, an objective aim of the norm. And the last one, the aims of the legal system. That probably you can find the last one in the Constitution. No, I think that not just in the Constitution, but principally there. No, and that's why we will say the aims of the legal message. Any legal message could be the Constitution, an agreement, a commandment, a verbal commandment. Yeah, and we should distinguish the aims of the legal message, the objective that is written most of the times in the same message, that the subjective motives, no? That are subjective. No. Well, why subjective? Because for example, I will ask you, if I sell you my computer, what kind of purposes you will have to buy my computer? Probably yeah, good. Well, yes, there have to be in good condition, but there are many. Why you're trying to buy some computer? The last computer or mobile or thing that you bought, tech machine. Why you buy it? Because you need it, no? Because I need to be connected and to attend the lectures of jurisprudence. No? Probably this will be the main aim. Yeah, something specific in your life. No, I need this, and that's why I buy this. No? This is more like the subjective motives. No? But there are the legal motives. No, the legal is, well, the legal is the common good in the legal relationship. I will pay, and I will receive that, and I will have the property Yeah, your personal, your subjective purposes. Well, I need to attend lectures. I need to go to university. But for that, there are some legal end that is, well, you have to acquire the property of this thing, and this is the legal aim, no? So in this, with this example, you will realize the same thing, that there could be many final causes, no? I'm showing another thing. Let's go to the analysis of the purposes of the message. Okay. Well, that's, I think that, let me see. Yeah. Yes. The purpose of the message, yeah, there could be many. Well, say the sense of the noun, the aims of the legal message that could be written in the Constitution, in the resolution, in any agreement, and the subjective motive. And now we will see the same thing, but in more detail in the code, because it helps so much, no? Probably is one of the principal rules to understand any kind of message, the sense of the message, and any kind of legal message, the sense of the legal message. No? Well, and the first rule to understand, to read the message is, well, to give credit, to think that there should be any sense of the message. No? And that's why the limit says it must be started from the presumption that the written noun is an arrangement of practical reason destined to achieve the common good, agreed or promulgated voluntarily and validly by the one who in charge of the community. Well, all the things is that all these elements are the elements of the law. What is the law? A practical reason destined to achieve the common good, agreed or promulgated voluntarily valid by the one in charge of the community, the authority. It's the same. What we are saying here, no? That we presume that any kind of law, any kind of positive law is valid. Yeah, it's the presumption. Have some sense. It makes sense. No? So, in the interpretation of the norm, this is the conclusion of the above, no? Of the last paragraph. In the interpretation of the norm or contract or resolution or any kind of policies could be, normally it is preferred first the most rational, natural, credible, just, and moral sense of the norm, and not the most irrational, natural, implausible, and just and immoral sense. And more or less, you will remember the harmonic interpretation of the Constitution. More or less is the same. Well, if the lower noun could be read in a contradictory way of the Constitution, or it will be harmonized. You have two interpretations. Now, the first one is absolutely contradictory, and the lower noun should be declared void and null because it's against. And the second way of interpretation would say, well, but if you read in some way, well, what the second should be preferred because it's just, it's in accordance with the higher law. It's the same thing that we are saying here now. No? We should prefer the just sense, but not the just, also the natural. No? If we can read the Constitution against the nature or following the natural conceptions, no? Well, probably we will prefer the last one. No? Or if we can read any norm of the Nazi regime in a moral sense or against morality, we will prefer the moral sense, because it gives more sense to the noun. That's why. Another, this is very used in administrative law, the second one, the B. The interpretation of the noun. Normally, it is preferred B, the most useful sense of the noun, and not the most useless sense. There are so many nouns, especially so many regulations, no? That it is not so clear. It seems to be absolutely irrational from time to time. How you can read that? Well, you read that and say, what is the authorities telling me about this thing? And you find that probably it's not so clear at all, but there could be one interpretation. So that interpretation you have to follow, and that interpretation will be the law. It is interesting. That interpretation will be the law. Let's go to this next one. The possible meaning of the law against the impossible. Once again, no? If it's shown, you have a doubt that it is asking you something impossible, very hard. Well, probably you have to prefer another sense of the norm, another interpretation. The act of the will to emanate the enacted law or sign agreement, and not the lack of will. If you see something in the papers of the printer of the government, you will think, well, here is a law. Probably from time to time in so many countries, you need some special phrases, no? For example, in the judgments, in the sentences, in the case law, the judge used to put some specific cases. Well, in the name of the Republic, I will conclude here in this way. Yeah, it's such a phrase used in so many places, no? In the name of the, what happens if you never say in the name of the Republic? Well, you should prefer the sense that you are, that judgment is finishing the issue, the problem in some other way, and in the useful sense of the judgment, no? And not the lack of will. In case of doubt, well, that the preceding rules, well, the doubts I will not talk about, just to show more or less how it works. No? It's very useful. I use it so many times as a lawyer, this kind of rules. No? Well, the aims of the legal measures. I said, no, it's not the same, the aims of the legal measure, that the subjective motives. Yeah. You buy your computer because you need to attend, and my family needs also, and I want to play, I don't know, Star Wars in my computer, the subjective motives but of the agreement. But the objective of the agreement should be, well, I want to acquire the property of the computer. This is the objective. No? The aims of the legal message. No? The legal message can have several aims, or more or less immediate, more or less objective. It helps to establish its meaning. First, the ultimate aim of the legal system, no? Is always the ultimate aim of any legal message. It is interesting. What is the ultimate aim? As you will remember, the happiness of the people. No? What we have so many battles, we sign contracts, we obey the law, because we want to be happy. And probably you can add so many things, but the aims of the legal system is the ultimate aim of any legal message also. But there is not just one aim. No? There are immediate aims. No? Each rule, part, or statute law has its own aims, and the intentions of the author, the legal intention of the author of the message. And finally, the most immediate purpose is the subjective reasons, no? That is developed here in the second one. This is more or less, as you will remember for sure, that there could be so many final causes, no? More immediate, more mediate, more far, more close, and well, the same in any legal message, no? The ultimate aim is the ultimate aim of the legal system of the human life, no? But the immediate end is the purpose, no? What I need, why I need that computer. This is, you can find, and if all of them helps you to understand the message, no? Because why he needs the computer? Well, to attend class and to play. And that why he wants to attend class. At the end of the day, is because he wants to be happy. That's why if I sell a computer that is not working, happiness will be not achieved. And so this will have this another kind of interpretation. Interpretation of a fraud act. It's a fraud. If I know that my computer is not working and I sell it, no? And I never say that. That's why this is more or less the same. Let's go to agent cause. No? The agent cause, we said that would be the people, no? The people, the legislative, the authorities. So it is quite interesting to understand the meaning of each legal message, any constitution, any law. And there could be the subjects of the message, the amplitude, the context, because these two things will help you to understand better. In the face-to-face communication, it's easy to understand the other, because you see the face, the hands, and any gesticulation of any kind of surprise. No? So it's easy. When it's only the written message, it's harder. It's harder. Also, for example, this kind of message, no? To throw one message to the sea in a bottle, no? And you don't know who will receive that message, no? You don't know. It's so different. It's I'm sending a message, for example, to my parents. They know so many things about me, and probably in a few words I can explain so many things. And I need this thing, for example, I need food. My parents know very well my problems about my stomach, and they will send me not some kind of food, but another, because they know what kind of food I need, because he knows me. They know me very well, no? But if I throw a message to the sea, I don't know who will receive that, no? I have to be very, very, I had to write it very clearly to anyone who will receive that message can read that, yeah? Any law, well, any contract is it's more or less like the communication with my parents, no? Because in a contract, you more or less know the other party, and the need of objectivity is less. But a law, a statute law, a resolution, and any norm of the authorities is like the message in a bottle. They throw the message to the sea. They don't know which one will receive that message. So the obligation of the authorities to be clear is higher, is very higher. And if it is not clear, probably the validity of the message is compromised. But and in the case of doubt, there will be no any kind of obligation or duty. This is more or less the things that you can find here in these two limits, 242 and 243. we can see just in a few minutes. Let's see. The subjects of the message, no? Well, legal message should be interpreted taking into account the amplitude of the communicative context. There are so many people, you have to be more objective, and you have to read the message in a more objective way. And if there are just few people, no, the ones who buy and the ones who sell, no, or you can take into account more the intentions of the parties and the expressions and so many personal behavior and a subjective interpretation of each party, no? And less the objective interpretation. No? The circumstance of the issue or drafter of the norm. For example, this is very helpful. No? If you know very well that the ones who wrote that bill of law is a famous jurist that in the past published a lot of book about that topic, if you read his books, you will understand better the Bill of Rights and the Declaration approved. Yeah, because you understand the drafter. Because he's a clever professor that uses a lot of techniques in the words. But instead of that, if one law is approved in your parliament, and I don't know, Kenya, or in the parliament of any country, that all politicians are not so clever, and talks not with a lot of precisions, no? So you will give another kind of interpretation to the second norm, because it was approved, but it was not written by a professor very precisely, you know, just with the common people, the common language. You will read in so different way the second norm. That's why it is so different, no? Well, I think that this is the amplitude. You should see the number of receivers, the senders, the ones who are linked between so many things. I think that you can read this, the circumstances of the author, also the receivers of the circumstances of each person will help you to understand this. And finally, you can find both the circumstances and the receiver circumstances. And the formal cause, no? The content. Probably here, the proper meaning of the norm, the breadth of meaning, the standard extensive interpretation, the standard restrictive interpretation, presumption of law. You can find in the analysis of what is the laws, what is the letter of the law, what is the content of the law, so many rules. I will explain just a little and very fast, because you have to understand, read it, and it will help you to read it. So let's go now to the content. No, we are studying at the content of the legal message. No, and as you have seen, the first rule of all is one, to give meaning to any message, the Bible, the historical documents, the literacy documents, books, novels, and so on. Don't you remember which is the first rule of interpretation? I say it 3 or 4 times, or 5 or 6. The first rule, there is Ali.
Is it the literal rule of interpretation?
Good. And why? Why is the first
Because
one?
okay, when I read it up, when I sort of heard about it, or when you're explaining it, it's the one that maintains the original meaning, the core essence or the original meaning of the message without any form of interpolation or any form of.
Well, because it's the only way to have any kind of access to the text. First, you have to read, and then you can try to first and read with the usual notions of the words, yeah, the usual that are in the dictionary, and with that you will give the first meaning, yeah. Probably you will find in the dictionary so many meanings of one word, no? Document, what is the meaning of document? You will find a lot of meanings in the dictionary, no? And you will choose one of that meanings. You have to choose, no? But normally when you are talking about document, you are talking about, so it's in Britain, well, and this is the first idea that came to your mind. This is the literal interpretation, and this is the first chronologically speaking rule of interpretation. No? Give the proper meaning of the words. No, it's the proper. This is the literal rule of interpretation. So first you have to give that meaning. I will say, but from time to time you have to amplify or give an extensive interpretation, and sometimes the contrary, you have to give a restrictive interpretation to some nouns. So normally the literal interpretation, but you should restrict your interpretation, for example, in criminal law. If you have any kind of doubt if this interpretation is valid, you have to see it will put this guy in jail or not. Yeah. And if with another interpretation that probably more or less could be possible, no, that guy is free, you have to choose the second one, because there is a restricted interpretation. For sure you have heard about that. I'm not saying anything new here, but it is the things that you can read here, no? So when you should have let's see, the restrictive interpretation, standard of restrictive interpretation, it will help you a lot in any kind of resolutions, administrative law, criminal law, civil law, and so on. No? Any kind of exception of a general norm should be read in a restrictive way. Any kind of exception, if you see in a constitution, normally you have some rights, except, well, this exception should be written in a restrictive way. No? All that is hate, for example, the sanctions, yeah, the sanctions, any kind of punishment, jail, and so on, should be written in a restrictive way. Yeah, it is also clear, no? And I will read just the last one, and also the ambiguities, no? For example, if some text of the agreement of you and your bank, where you have an account, a bank account, a checking account, for example, who wrote that agreement? Well, the bank. You just only accept to have the possibility of have an account in that bank. No? What happens if some provision in that agreement is not so clear? Well, you have to read against the bank, against in a restrictive way in favor of you, so the ambiguity should be restrictively against the bank. read it in a restricted way. So this could be the main ideas here. No? Everything that is hateful, sanctions, the ambiguities also, well, and so many other things. You should do finish to read that. On the other hand, it deserves an extensive interpretation, everything that enjoys the favor of the law. For example, any value, any legal value, any presumption have the favor of the law. The things mentioned in a general way, all people have the right to, well, this should have an extensive interpretation. The provisions where the legislator has not distinguished, no? If the legislators never distinguish between man and woman, well, we should apply that provision in general to both. No? That were a strong analogy, well, we will see this, and the clauses in favor of the donor, the testator. If you want some explanation, I think that here you know that just in Latin and Spanish. Well, in any case, you have Google Translator, but I think that is more or less comprehensible. You can find here also all the rules of the context inside of the norm, the context between of the norm, the context with the legal system. There are the context of the legal message with the structure of the norm and the motivation, the prologue, and the recitals and so on, and the context of the legal system. We have talked about that when we talk about the schools of interpretation. The opposite sense is, I say, for example, I don't know, someone of you have the right to ask me, well, I'm excluding the others, no? If I say just one, obviously I'm saying the others not, no? It's the opposite sense, no? If I sell to one, I'm not selling to everybody, no? And so on. So you can find here so many rules, the major and minor sense, no? Well, if I say the general rule is this, and you can do many things, obviously you can do the less things that are inside of this. Well, you should read this, and if you have any question, you can ask me by email, or we can have another meeting. It will help you a lot. It will help you a lot, and you will use this whole days of your life if you practice law, no? Major and minor sense. Give any sense, which is the, I will finish with this, no? With this, we have seen more or less 40 rules of interpretations. So you have to take it slowly and to which one is the principal one for interpretation? Probably one of the most important could be the final cause, no? The final, because it gives sense to all, no? But people used to say the best interpretation is the one who use all the methods of interpretation, all, yeah. And if you work in a very prestigious law firm, so many people will ask you, well, how these complicated issues could be interpreted with the laws of the country, no? So the best thing is to use as much of the resources that you can. For example, in an informed to your client, you will put the history of the norm is this, and the sense with this, and the principal aim is this, and and you can use all the rules to understand better the notion. Probably the contrary part will use some of them, but if you use more, probably you will be able to understand better the norm and to win the cases. No, this is the everyday work of the lawyer. So it is good to study all these things. Well, finally, I will put in the last part of the class, I will talk about legal gaps and Epikeia. What happened if we are trying to understand what the law should be in one case, but we have not written law? Yeah, we have not legal message to interpret, to be read it, no? To apply to the case. If we have no legal message, there is a gap in the legal system. No, I have not the solution in the legal system, obviously in the positive legal system, the positive law. There is a gap. No, so we can apply some tools like Epikeia. I don't know if you have heard about Epikeia or the analogy. No? From time to time, the legal system is like this elephant. No? How many legs have this elephant? How many legs? This elephant, not all elephant. Effie, yes.
I see 4.
4. Are
Yes.
you? And what about this? Or this one? You can see the points here, no? Or this one?
They're not complete, so they're not legs. They are spaces.
But this is neither nor is complete. This one. Neither this nor this.
I see 4 feet. I can't see. I see 4 feet.
Well, the answer should. This is a typical illusion, no? The chat. This is an illusion. I don't know if you realize that this is an illusion. Our brain, try to feel the things. This elephant is not possible. It is an impossibility. No elephant could be like in this way. It is not the shape of any elephant, real elephant. But our brain try to feel the thing that needs to complete the image, and we have the feeling, more or less is the same feeling with the legal system. Most of the jurists try to find all the answers in the Britain law. And there is a lot of legal gaps and contradictions and things that are not well done. So we cannot have all the answers in the legal system. It is impossible. Because the legal system is a creation of the human mind. It's a creation. I'm trying to put things together with the reality, obviously. But this, at the end of the day, is a creation, and any human creation is not perfect. So, what we can see, well, there are some norms. I will put you an example that you will realize. No? Think about in the traffic of the city. No? You are driving a car because you need to go as soon as possible to the hospital. No? And probably you know very well the rules that you have to fulfill in the traffic, no? And you see some traffic light, no? And the traffic light could be so many possibilities. Don't you know the rules of the traffic light for sure, no? Red, you cannot cross. If it is green, what happens if it is green, and what happens if it is yellow, no? And the laws of the country usually say, red, don't cross. Green, you can cross. Light, you can cross, but be careful, no? But in the reality, there could be so many possibilities. This could be all the possibilities, more or less, no? First, if you go to some place and you see the light traffic is not working, is what you should do. You will find in the written law, and no, the written law just say red, yellow, and green. What happened with that? No. So it's a legal gap. Yeah, it's a gap in the legal system. Well, probably you will cross. You say, well, there is no color, there is no obligation. I can do the things. The second option, no, you have two lights, no, and it's trifling. It's trifling between yellow and red. Sorry, yellow and green. From time to time, I have seen that, no, on, off, on, off, on, off. Well, probably you should see, well, I had to cross with some prudence, but if you hurt someone and in front of the judge, what you will say? Well, that says something or not? Well, this is also happened. No, I saw that red and green or yellow. Well, seems to be so easy, or seems to be. Let's put the easiest case. No, green. We have red, green. We can cross. And what happens if there's somebody in front of us working? The laws of the country clearly says, if you have green, you can pass. You have the right to pass. But you are seeing some grandmother walking very slowly. You can cross or not. You have the right. The law says clearly you can. You can't. Obviously. Against the law is clearly says no. Green, you can cross. But in this case, no. So sorry. Because it is not rational. Yeah, to kill, because some letters say you can cross with green. To kill someone, no, it's not possible. It's not possible. Even in green. And let's go to the contrary case, no? If you have red, and you see that there is nobody there, yeah, you are alone, and there is a lot of space, and you see very clearly that there's nobody, and you have to go to the hospital because some parent of you have an emergency. What you will do? You will say, well, I have to stop. It doesn't matter if my parent pass away. No, obviously you will cross. And I saw so many cases that not only you, but if there is a policeman, the policeman will help you if you explain. I have this problem, my parent it's in an urgency. The police will help you because the police is normally a rational being. Yeah, normally. Well, as you see, the laws of the country could be very clear. This is so easy to understand how the lights of the traffic works. And you should say, well, with a lot of clarity, they don't give me all the solutions for all the cases of my life. In the legal system also, no? That's why there is a thing that is called Epikeia, very well explained in limit 260, and the limit is so easy. It is, it's just this one limit, but very helpful, very helpful. When we can apply the Epikeia, and what is? The Epikeia is the correct, I will begin with this, the correct definition of the law made on a specific case that ultimately lacks positive regulation in the legal system. That ultimate lacks regulation. It seems to be clearly green, you can cross. But in this specific case, is one person is walking in front of you, you cannot. Yeah, because it seems to be that it's clear that you can apply that, but it doesn't apply really. Although apparently some positive norm could be applied to fulfill the aims, values, and principle of the legal system. The Epikeia constitutes an exception to the general positive norm. It's an exception, and that's why you should, all exceptions, remember, all exceptions should be interpreted restrictively, and therefore must only occur when there are proportionate causes. This is the restrictive interpretation. No? We have seen about this. No? There is cause when the literal application of the positive law would cause injustice. No? Well, I want to take well the final the final ideas of that of this paragraph about equality, analogy, and proportionality now. No? We will talk about this. So let's talk about true lies. True lies. No? True lies like what? Let's talk about equality. No? Equality, obviously, as we have talked about a lot of equality. No? And we say that in all the things that the humankind share, for example, nature, we are equal, but in other things, in the rest of other things, well, we are different, really, no? It's about proportionality, no? It is the divine proportion, one of the numbers of the mathematicians, no? And they talk about analogy and many other metaphors, no? Metaphors. For sure you have heard some metaphor. Love is a fruit in season at all times and with the reach of every hand, Mother Teresa. On the other hand, Charles Bukowski said, no, love is a dog from hell. Quite different and opposite point of view of the same thing. No? All love, but obviously love is not properly a dog. Yeah. Love is not properly a fruit, but it's a metaphor. No? So an illusion. And this I want to put you now to show you how all these kind of things works. I will first explain the usual explanation of analogy and metaphors. This is the usual. I don't believe in so much in this that I will copy one infographics of internet. No, he said, well, analogy. When you use analogy, when you are comparing two completely different things to each other, two completely different. And when you use metaphor, you are writing a phrase. When you are using a metaphor, you are writing a phrase in a word while actually referring to something else. Is comparing versus referring. Comparing two specific things, more or less close, and referring to an external and far thing. No? Some examples. No? First, remember the title. No? Analogy is the blue. No? Examples of analogy. Life is like a race. No? It's more or less like the metaphors of the other. No? So you can see now that there is not distinct, clear difference. No? Love is like a fruit. Life is like a race. No? You can, well, more or less, we can say with you that love is a journey. Example. So, argument is war. Is an analogy. a book is like a garden carried in the pocket metaphor. Well, you can see so many examples. No? I tend to consider, I have a lot of studies on analogies, and that's why I'm saying this. No, published as a study just in Spanish, so sorry. No? That there could be some grades of analogies. One very strong analogies and others very weak analogies. The weakest one are called metaphors, because it's something not very connected but related. No, it's not a strong comparison. Some very far. A movie is a roller coaster ride of emotion, very far, and she's drowning in work. Well, this is very close. So you can see that there could be so many degrees of analogies. No? The last one is the metaphor. No? And you can find types of analogies: pattern, hole, battery, flashlight, hard drive, computer, no? Time, March, spring, because it's a part of, no? We are talking about the spring, we are talking about March, more or less, and so on. No? So now I will put you some illusions, no? And I don't know if you realize that straight all the lines here or not, or are curved. Here's illusion. How do you see that image? No one of you?
The lines look straight.
Straight? Really?
Yeah. When you look at them like closely, they are straight.
Yeah, but you have to look at it closely. Another way to see, if you put a pencil or a rule, use a rule, and you will realize that all are straight. Yeah, but you need to use a rule. Use a rule. Have some rule, because I will show you another thing. Let's see. This one are moving or not? Have each leaf have some kind of movement, or is
they weren't moving until
it seems to be. No? But if you isolate each graphic, each leaf, you will realize that it's quite static. Yeah, it's just an illusion of your mind. You have to put, for example, if you put your hand like this in your screen, you will realize that there is no movement. No? That the movement is made by your brain. You have to individualize something. I'm giving you two rules to understand analogy and equality. Singularize things and put a measure with this graphic. Another, how many colors do you find here? How many? Obviously, you can use one of my clues, yeah. 4 colors. No, there are just 3. There are just 3. Green, white, and pink. The pink is the same. It's just an illusion. It's the same. If you use my rule, individualize the thing, you will see that the pink is the same in one here and here. It's the same. I don't know if you use your hand, you will see. Let's put another trick. Which one is longer? It's larger, sorry. Noun. No, yes. Here is one is clearly longer, larger. Sorry. Use the same trick that I showed to you. Take your rule and measure it. Please measure. Which one?
The second.
The second, yeah, it's just an illusion. And how you resolve the illusions that could be in the legal system? With a measure. We will talk about the measure because we need a measure to these kind of things. Which one is bigger? I'm talking about the orange circle, no? It's larger also, no? Which one?
The second one.
No, both of them are equal. Yes. You can measure, you can use your pencil and measure it. So, what I mean with this, no? We have to individualize and to have some measure to distinguish so many cases. And we will say what is identical must be treated identical, but we have to measure. What is proportional, we have to treat it in a proportional way. What is similar, we must treat this in a similar way, using analogy. The first, when we have two identical cases, we should use the principle of equality. When we have some proportion, the principle of proportionality. With this similar, we use analogy, the last one. It's not obligation to treat in the same way. What is not more or less equal. So this could be the synthesis. What is the measure? What is the measure? The measure is called tertium comparationis. Tertium comparationis. It is, no? You have the two principles of equality, of proportionality, and of analogy. The three of them use the same rules. It requires the existence of two or more elements that should be compared. It requires also the existence of some tertium comparationis, some rule, some measure. If you don't have any measure, you cannot compare them. You cannot compare, for example, elephants and seeds. Because what is the element of comparison? Probably life. So life is, yeah. But the same tertium comparison is the same element, the same measure could be applied, should be applied to both. The same tertium comparison should be in each element of the comparison. And finally, it requires the existence of some relations between those elements. Obviously, in equality should be equality, in proportionality, proportion, in analogy, similarity. And that's why the functions of the analogy is not just always a rule. No? It could be a rule if there is a strong similarity between them. Strong similarities, but not identical. If there is a strong similarities, more or less will work like the principle of equality and will produce a lot of laws. But if not, probably it will help only to interpret the law, to give some interpretation of the law. And well, have so many limits, exceptions to general rules, the impediments, and so many things. Well, I don't know if you enjoyed the illusions. but these are illusions that give some idea of how the analogies could work, the thing that seems to be similar or not. You have to find the tertium comparaciones, the rule to individualize each element, and then to put what kind of connection of relation you will have. And well, we have to finish. Thank you so much for attending my lecture today.